number 17, the people of the state of New York versus Cesar Garcia. Counsel?
Good afternoon, Your Honors. My name is Mark Zeno, and I represent appellant Cesar Garcia. May I reserve 2 minutes for rebuttal, please?
You may, sir.
Thank you.
Welcome.
The only issue preserved by the people below and reviewable by this court is whether Mr. Garcia was entitled to a jury trial because a conviction for any of the charged offenses would make him deportable. This court's decision in Suazo answered that question. The Sixth Amendment guarantees a jury trial to a non-citizen facing trial on a charge that carries the potential of deportation. Respondent's primary claim on this appeal, that Mr. Garcia failed to make a threshold showing that a conviction would make him deportable, is unpreserved and unreviewable in this court.
Counsel, what if we were to assume that we reached the contention raised by the people that the defendant failed to meet his burden and established that he was charged with an offense that carried the potential for deportation, and if we also assume that the defendant must show that he was charged with offenses that carried the possibility of deportation in his specific circumstances, did he preserve his argument that he was charged with 3 separate crimes involving moral turpitude and that this was not a single scheme of criminal misconduct?
Well, yes, he did. For starters, Suazo, which guarantees the right to a jury trial, had precisely the same threshold showing of deportability.
But Suazo was a bit different, wasn't it? Because there you had a domestic violence offense, and that automatically was going to be deemed a deportable offense, wasn't it?
No. Mr. Suazo, in his motion, and I went back and I looked at the appendix, alleged only this single sentence when he asked for a jury trial. As a non-citizen, should Mr. Suazo be convicted of any of the misdemeanors for which he is charged, Mr. Suazo will be deportable. No citation to what provision would make him deportable, no citation to his circumstances. That was it. Just, this will make me deportable. And in Suazo, the Court of Appeals, this court, found that that was sufficient to meet the threshold showing of deportability. And I'll compare that to the language of Mr. Garcia's motion, which is almost identical. In his motion, he said, Mr. Garcia is a non-citizen for whom any of the charged B misdemeanors would result in deportability under 8 U.S.C. 1227. So it's essentially the same, but there's more. He cites a provision. And just as in Suazo, the court found that it was sufficient to make that threshold showing, the same rule has to apply here. It was enough in Suazo, it's enough here.
Well, Mr. Garcia also cited a couple of district court cases, right?
He did.
And then cross-referenced those to penal law statutes.
Yes, he did that, and the people never challenged his allegation that he was deportable under that section of the United States Code. And it's too late to make that challenge now on appeal. The threshold showing was stronger here than it was in Suazo. There's just no distinction to be made here.
I mean, some of the people's argument, though, is that, in a sense, it's a little unfair to hold them to anything because Suazo hadn't been decided.
Well, there is unfairness to requiring preservation, anticipation of a change in the law. But this court's precedents for 30 years have required that. I cite Reynolds in my brief, where it specifically says counsel is required to anticipate changes in the law and make timely objections. That's something this court has done over and over again. In the depraved indifference line of cases, Feingold not just recognized a new right, but overruled existing precedent, naming depraved indifference as a mens rea element, and going forward, and parties, defense lawyers were required, if they wanted to challenge that element of an offense, to have preserved it even in cases before Feingold was decided.
Counsel, I'm on the screen.
Yes.
Good afternoon. So, but wasn't the issue already percolating below? I mean, it's not a surprise to the district attorney's office.
No, of course it's not a surprise. These motions were made relatively contemporaneously in Suazo and in Garcia in 2 different counties. It was nothing new to the parties. Again, putting them on notice that this is an issue percolating out there and they have an obligation to make every objection they have. You know, the objection rule usually works in the defendant's, to the defendant's detriment. Here it's working to the people's detriment. There is unfairness there, but part of reviewability, and especially in this court, is that we require lawyers to anticipate arguments so that a full record can be made. Here, for example, if that objection had been made, if the prosecutor had challenged that threshold showing, Mr. Garcia might have been able to point to circumstances as to why he would be deportable if he was convicted of these offenses. Explain.
Counsel, over here, I'm sorry. I think the unfairness that Judge Wilson was just alluding to comes from the fact that, as you say, the motion papers make a sort of blanket statement that conviction of any of these offenses could lead to deportability. And there is a little more than that. There's some citations to cases, one involving forcible touching and one involving sexual abuse. But there is no elaboration on the argument about the scheme or about the moral turpitude dimension to all of this. And what seems difficult for me to grasp, at least mentally, is that there was a requirement that they address arguments that were actually not made in the papers or at oral argument. Is that the preservation requirement you're saying exists?
That's absolutely the preservation requirement that's applied every day in the courts, Your Honor. I point in my briefing to People versus Hunter, a decision from this court in 2011 relating to standing. Defendant made an omnibus motion. There was a hearing granted. Never made any allegation of standing, never tried to prove standing, and there's black letter law from this court that says it's the defendant's obligation to prove standing. The people never challenged it. Therefore, it was waived. You can't raise issues for the first time in this court, particularly where the party against whom the objection would be posed has to make a factual showing of something.
I guess the issue, though, is one could take a view that the issue was never raised. It wasn't raised by the defendant. It wasn't addressed by the people. It doesn't even really become an operable issue until Suazo's decided and you're at the appellate term.
I disagree, Your Honor. It was raised. He said a conviction for this offense would make me deportable. That's raising it. That's putting everyone on notice that if he's convicted of this offense or more than one of these offenses, he will be deportable. That's all that's required, is to put the parties on notice that a result will happen. And the people chose
So, counsel, is it your argument that it's simply the mere possibility of a conviction that's sufficient?
This simply the possibility that should there be a conviction, the person will be deportable. The client will be deportable. Yes, that's what Suazo says.
Thank you, counsel. Counsel?
Good afternoon, Your Honors. May it please the Court. David Cohn for the people. This Court has never applied either the preservation rule or the LaFontaine rule against a respondent in the criminal appeal where there has been an intervening change in the law. That rule makes sense because courts and parties should be permitted to rely on the law as it stands. They should be permitted to rely on this court's precedents when they're making decisions. And even where a new rule applies retroactively on appeal, as here, the courts do not grant relief to the party based on the change of the law unless that party has met the standard that is required by the new change in the law. And Suazo provides a perfect example, Suazo itself. In Suazo, the people did not dispute the defense assertions that he was a non-citizen or that the charges against him included deportable offenses. Instead, the people opposed the defendant's motion on the sole ground that deportation was a collateral consequence arising out of federal law that did not constitute a criminal penalty for the purpose of the Sixth Amendment right to a jury trial. This court, before granting the defendant relief in Suazo, applied the new Suazo standard and held that the defendant, under federal law, was entitled, would be deportable based on the conviction of the domestic violence offense of obstruction of breathing or blood circulation. So therefore, there was a deportable offense charge, and under the Suazo rule, a jury trial is required. The defense in this case cannot cite a single case where the preservation rule or the LaFontaine rule was applied against the respondent on appeal in this circumstance where there was an intervening change in the law. And this court should do in this case exactly what it did in Suazo and review the merits of the defendant's claim that he's entitled to a jury trial because of the
So
deportation consequence.
you did have a, sorry, over here.
Yeah, hi,
Yep.
Judge.
You did have an opportunity in the appellate term to submit supplemental briefing on Suazo, and I don't believe you made the arguments you're making now there. That is, you defended on a different ground, which was that it was really only the crime of conviction that mattered.
Your Honor, we raised all the arguments in the appellate term. The appellate term brief is in our supplemental appendix, so Your Honor can look at that if you would like. But we raised all the same arguments in the appellate term that we are raising to this court. That not only was the operable crime here is the one of which he was convicted, but also that even if you consider all 5 crimes with which he was charged, he was not subject to deportation because it was a single scheme, and therefore, even if you consider all 5 crimes, there are not 2 crimes involving moral turpitude that would subject the defendant to the penalty of deportation in this case. And you could take a look at our appellate term brief in the appendix if you would like, Your Honor.
Is it your argument that the reason that you didn't make an anticipated argument of what the change in the law might be in the future, because the trial judge made it pretty clear what his perspective was and that there was no incentive or any reason to make any further argument there?
Absolutely, Your Honor. The trial judge in this case and the people in this case do what litigants do in the trial courts all the time. They rely on precedents of this court. And the trial judge said point blank that he believed the Court of Appeals had taken this issue out of his hands. I think that was the trial judge's exact quote, that this court had taken the issue out of his hands. And he speculated that, yes, maybe the Court of Appeals would reconsider at some point what it meant for the criminal penalties to render the crime serious. But under the Urbaya standard, which was the Court of Appeals case cited by the people below, the trial judge said, look, my hands are tied. There's nothing I can do at this point, and didn't even ask the people to submit responsive papers. In fact, the same day that the defense filed their request for a jury trial, the judge said, I just want to have an oral conference about this. Didn't even give the people the opportunity to submit responsive papers. So, Your Honors, what we submit is that if this court believes that there should have been further development of this issue, that a limited remand for that purpose would be an appropriate remedy, that the trial judge, without reversing the conviction, send the case back to the trial judge, let the trial judge decide under the circumstances of this case was the Suazo standard met, and if so, then the defendant would be entitled to a jury trial. Or alternatively, if this court believes that the record is sufficient to review the issue on the merits, it could do what the appellate term did and say that the record in this case does not establish that the defendant was convicted of a crime of moral turpitude or even charged with 2 or more crimes of moral turpitude that would require a jury trial under the Suazo standard.
Since you've gotten to the question of relief, can I ask you just a practical question? My understanding is that Mr. Garcia is not in the United States any longer. He's been removed. So his counsel would like to have the indictment, the accusatory instrument dismissed. And is there any practical difference between doing that and simply vacating the conviction and allowing re-prosecution?
Well, Your Honor, this was a sex crime on the subways. This is a serious offense that the people do not believe that this would be an appropriate case.
Oh, I got that. I'm just asking as a practical matter, because he's not here, you can't really retry him anyway.
I suppose he could potentially be retried in absentia. That's another issue that would have to be resolved by the courts below, whether the trial could proceed in the defendant's absence under these circumstances. Certainly, if the defendant ever returns to the country, then there should be the ability to try him for the charge. I'm not prepared to address the issue of trying in absentia. I don't know what the answer to that question would be on this record. Your Honor, just turning briefly to the merits of this case, the defendant has not met his burden under Suazo, and this court placed the burden squarely on the defendant to show that the crimes that he's charged with would carry the possibility of deportation. Here, if we just look at the crime of which he was convicted, which we submit, Your Honors, that's the only crime that's actually a live controversy in this case anymore.
Well, how can that be, though? Because you have to determine the jury trial right before the trial occurs. So you're not going to know the crime or crimes of which he's convicted at the point where you've got to determine the jury trial.
Yes, Your Honor. So, and there's a difference between what an appellate judge does after the fact and what a trial judge does at the time of trial. Of course, a trial judge looks at all the charges and says, considering all the charges together, is this defendant entitled to a jury trial? An appellate court doesn't reverse for errors that are no longer relevant to the appeal. For instance, if there was evidence admitted at a criminal trial which was relevant to one count only, and the defendant was acquitted of that count, this court will say, well, that error in admitting that evidence was harmless.
Yes, but of course, if you have a jury trial right as to any one of the charged offenses, you have a jury trial right, period.
That's a statutory right, which is merely an issue of court efficiency. It's not the Suazo constitutional right to a jury trial. This court said in Suazo that there's a Sixth Amendment constitutional right to a jury trial in the circumstance where a defendant is charged with a deportable offense. The 340-43 statutory right basically says we don't want trial judges doing very unwieldy things like saying, well, there are 5 counts in this information. One of them's a violation and 4 of them are A misdemeanors. We're going to have a jury trial on the A misdemeanors, and then the judge makes a fact-finding decision on the violation. It's basically just a single fact-finder rule for the organization of the...
Remember, counsel, I think, I'm on the screen. Good afternoon. We know how that works, but you just said it yourself. You quoted it yourself. Suazo says that the court looks to the crime that's charged. It doesn't say conviction.
Right, Your Honor.
I mean, it's in the opening paragraph, and we were very clear.
Right, Your Honor, absolutely, Your Honor, and that is directed towards the trial judges. That's giving guidance to the trial judges. The question of what an appellate court is going to do after the fact, of course, appellate court isn't going to reverse on error that is harmless or moot at the end of the day. And we submit, Your Honor, that in this case, anything relating to the 4 acquitted counts is moot or at least harmless at the end of the day in this case. And, Your Honors, even if you consider all of the counts of which the defendant was charged at the time of trial, still under the federal law that the defendant cited in his motion papers, there have to be 2 separate convictions of crimes involving moral turpitude for there to be deportation consequences. Interestingly, in those very cursory motion papers, the defendant did not even allege that there were 2 crimes involving moral turpitude, did not even recognize that that section of federal law that he cited required that there be 2 convictions of 2 crimes involving moral turpitude. So the defendant didn't even put that argument before the trial court. So everything the defendant is saying about how this was actually 2 or even 3 different schemes, that was not raised in the trial court. Beyond that, Your Honors, even under the stricter Board of Immigration Appeals standard, there was only one intent here in this 30-minute episode where the defendant is in basically one constant frame of mind where he's going to gratify himself on the subways, and he commits a lewd act on the platform and then rubs up against 2 women on subway trains in quick succession. There's no Board of Immigration Appeals case that the defense cited that said that something like this that happens with a single intent over the course of 30 minutes constitutes multiple schemes. The cases the defense cited...
Well, but counsel, if I can interrupt you, I mean, the federal statute says convicted of 2 or more crimes. It doesn't say 2 separate convictions, which I think you were suggesting at the beginning. But in any event, different victims, different locations, right? I mean, their time has passed in between. It does seem hard to really look at this as a single scheme under the Bureau, right, the BIA's view.
Well, Your Honor, the statute says 2 or more crimes not arising from a single scheme, right? So it has to be more than one scheme. And here, it all happens in very quick succession. It's the same officer who's following the defendant as he gratifies himself and then rubs up against 2 women on the subway platform. So this is not something that's consistent with the BIA cases cited by the defense where you had events that occurred after multiple hours in between or even years. One of the cases they cited had a credit card fraud scheme that went on for years. At the very least, there has to be a separation of hours, not just a few minutes.
Thank you, counsel.
Thank you,
Counsel?
Your Honor.
Beginning extremely briefly with that last point, there's nothing in the BIA law that says that there needs to be a time separation between events that are to make it a separate crime. There were 3 completed incidents here, 3 completed crimes, and under BIA law, there's really no doubt that they're separate incidents. But I want to get back to the first point that opposing counsel made, because it was said as if it was a reasonable request, but it's not a reasonable request. The prosecutor is arguing that a different standard of preservation should apply to the people than to the defense. In Reynolds, this court held, courts are continually reconsidering old precedents, and if no objection or equivalent was required, objection would never be necessary to raise a question of law where it is urged that some former decisional law be changed. Opposing counsel says, okay, that's good for the defense. They have to anticipate changes in the law, but not respondent. Respondent gets a different rule. This court has never applied a different preservation rule for the defense or for the prosecution, because there isn't. Fairness is two-sided. What rules that apply to the defense need to apply to the prosecution as well. And respondent says, I can't cite to a case where it was held against, this preservation rule was held against the respondent, the people. That may be correct, but there are dozens of cases where it's held against the defense, where the defendant is required to anticipate changes in the law and make objections in anticipation of those changes. And it would be grossly unfair to allow the people with their superior resources not to follow the same rules.
Thank you,
Thank you.
counsel.